Hello, and welcome to the second half of Session A of the Peace Officer Certification Workshop. My name is Michelle Weiler. I'm the Bureau Chief of the Certification Bureau, and during this presentation, I'll be walking you through the updated Notice of Appointment process, Peace Officer Certification, and the new process for submitting a Notice of Separation. But first, a reminder of our disclaimer. The process for notices of appointment and separations have changed. There are no longer going to be a notice of appointment termination. Peace officers are now required to have a basic certificate or a proof of eligibility if they are not eligible for a basic certificate. More about that in just a moment. With the implementation of Senate Bill 2 come changes to existing Commission regulations, as well as the adoption of new Commission regulations. So what's changing with regard to Peace Officer certification? Commission Regulation 1011 will now strictly deal with qualifications for public safety dispatcher and record supervisor certificates. All certificates related to Peace Officer certification, including the new proof of eligibility and the basic certificate, will be found in Commission Regulation 1202. This is a new regulation found under Article 4. What else is changing? When making a notice of appointment in EDI, you will now be required to upload an attestation of Peace Officer eligibility for all new Peace Officer appointments to your agency. This must be done within 10 days of appointment. You will also have to upload an affidavit of separation at the time that you're making a notice of separation in EDI. The process has now been bifurcated. The process formerly known as the Notice of Appointment Termination is now the Notice of Appointment and the Notice of Separation. Both need to be completed within 10 days. The Proof of Eligibility is a new certificate introduced through Senate Bill 2. But what is it? Well, it's a certification, or permit if you will, that confirms an individual is eligible to be a peace officer in the state of California. Who needs a Proof of Eligibility, or POE? The POE is generally issued to peace officers who are not yet eligible for, or will not become eligible for, a basic certificate. Well, what is the difference? Some of the main differences between a proof of eligibility and a basic certificate are, 1, that the proof of eligibility is non-transferable. It is both officer and agency specific. That means that an officer may have multiple proofs of eligibility in their possession. Perhaps they are a reserve officer who was never a full-time peace officer issued a basic certificate, and they are a reserve officer at multiple agencies. They would be required to have a proof of eligibility assigned to each agency for which they are employed. A proof of eligibility also expires upon separation from an agency, whereas a basic certificate follows a peace officer throughout their career, no matter where they are employed. For example, a probationary officer who separates from one agency during probation and has not yet been issued their basic certificate, their POE would expire upon separation, and upon employment by a new agency would be required to obtain a new POE until such time as they become eligible for a basic certificate. Who does this requirement apply to? Peace officers employed by both post-participating and non-post-participating agencies are required to possess either a POE or a basic certificate. The exception are employees of CDCR, parole officers, probation officers, and reserve officers who work for non-post participating agencies. They are not subject to the requirements of Senate Bill 2. All peace officers who do not currently possess or are not currently eligible to possess a basic certificate will be required to apply for proof of eligibility within 10 days of appointment, regardless of whether they are employed by a post-participating agency or a non-post-participating agency. The classifications of peace officer required to possess a POE or basic certificate are those classified under PC 830.1, including your 830.1C jail deputies, PC 830.2, with the exception of those described in Subdivision D, which are the CDCR employees, PC 830.3, PC 830.32, and PC 830.33. All hiring standards are now in effect and have been in effect since January 1st of 2022, including the requirement for peace officers to possess either a proof of eligibility or a basic certificate. Unfortunately, at the time this bill was passed and went into effect, Post did not have the capacity to issue a proof of eligibility as this was a new certificate. For all peace officers properly appointed to their agencies between January 1st, 2022 and December 31st, 2022, who do not already possess a basic certificate, Post will automatically issue a proof of eligibility on January 1st, 2023. Agencies do not have to apply for a proof of eligibility for those individuals appointed in what we are referring to as the gap year. After January 1st, 2023, agencies are required to apply for a proof of eligibility for their new peace officers. To make this a little easier on agencies, Post is tying this process to the notice of appointment. When an agency appoints a brand new peace officer to their agency, regardless of whether or not they are brand new to the occupation or they are a lateral officer already in possession of a basic certificate, they will be required to upload what is known as an attestation of peace officer eligibility. More about this in a moment. If the officer does not already possess a basic certificate, Post will issue a proof of eligibility at that time. If the officer already possesses a basic certificate, no proof of eligibility is required. The screenshot on your left shows the notice of appointment in EDI. You will notice at the bottom of the page, before you complete your notice of appointment and submit, you will be prompted to upload an attestation of peace officer eligibility. The form can be downloaded from this page in EDI or found on the Post website on the Forms tab. You will notice that the attestation of peace officer eligibility must be signed by your agency's hiring authority or authorized designee. One key change to the notice of appointment process is that it will no longer automatically add the individual to your Post roster. When you hit submit, the notice of appointment will be forwarded to Post for Post staff to review both the notice of appointment and the attestation of peace officer eligibility. Staff will review both documents to ensure that the form and the notice of appointment screen in EDI are complete, accurate, and have matching information. If appropriate boxes are not checked or initialed, the form may be returned. If all is correct and all information matches, Post will approve the notice of appointment and the individual will be added to your Post agency roster. Once you submit your notice of appointment, you will receive a confirmation. You may print this screen for your records. You can also check on the status of your notice of appointment submission. The statuses you can expect to see are approved, returned, canceled, or denied. If a notice of appointment was approved, the newly appointed peace officer will be added to your agency's post roster, and if necessary, the proof of eligibility will be issued by post. Post will not be mailing a copy of the proof of eligibility to the officer or the agency. The officer will have to create a PostPass account and log in to download a copy. The proof of eligibility will also be noted on the officer's post profile. Returned. If your notice of appointment was returned, it means that post staff found an error either in the EDI entry or on the attestation form. Both will be returned to the agency with a comment noting the discrepancies. Agencies may fix the issues and then return the notice of appointment to post. Canceled. The attestation was accepted as complete and the officer was added to the agency's post roster. However, during the compliance audit, it was revealed that the background file was incomplete or the regional consultant discovered a disqualifying factor. Denied. A disqualifying factor arose, or the peace officer was not a qualifying classification and is not required to have a proof of eligibility or a basic certificate. If a notice of appointment is returned, denied, or canceled, the agency will have an opportunity to remedy the situation. The regional consultant or post staff will grant the agency an initial 30 days to correct any deficiencies. Post staff or the regional consultant may grant 2 subsequent extensions if the situation requires it, and due diligence to remedy the situation is shown. For example, you appoint an officer to your agency, the notice of appointment and attestation are approved, and the officer is added to your post roster. Within 60 days, the regional consultant comes to your agency to complete a compliance audit and discovers that the package is missing the full military record. The agency is granted 30 days to remedy the situation. 30 days later, the regional consultant conducts a follow-up with the agency. The agency is still unable to produce a full military record for the individual officer because they are still waiting for the record to be provided by the branch of service. In this case, the agency is conducting due diligence to remedy the situation and may request and receive an extension by post. However, if the agency does not show due diligence to remedy the situation within the original 30 days, no extensions will be granted, and the officer's appointment to the post roster will be canceled. What does this mean for agencies and the involved officers? Well, in either case, it could result in a delay of an appointment to the agency's post roster, as well as the issuance of a POE. Cancellation of an appointment to a post roster will cancel the proof of eligibility. If you have a new peace officer that only possesses a proof of eligibility, that peace officer is no longer eligible to act in a peace officer capacity in the state of California because they do not possess the proof of eligibility. It is in the best interest of both the involved officer and the involved agency to remedy any deficiencies within a timely manner. In the past, the notice of appointment and termination were completed in similar fashion in EDI or on the same form, the notice of appointment termination. However, this process has changed as a result of the implementation of Senate Bill 2. The bill now requires that an affidavit of separation be submitted to post within 10 days of an officer's separation from peace officer employment. Thus, the process has been bifurcated. Upon making a notice of separation in EDI, agencies will be required to upload an affidavit of separation. This is required whether or not an officer is separating in good standing. The Notice of Appointment Termination form has been deactivated and will no longer be accepted in paper form. All notices of appointment and separation must be completed in EDI. So how is the affidavit of separation submitted? The agency shall complete this form, which is downloadable in EDI or found on the Post website on the Forms page. It must be submitted within 10 days of separation, and it shall be signed by the agency head or authorized designee under penalty of perjury. This is the new affidavit of separation. If you see Section 2, Termination Separation, there is new information that is required of agencies. Box 10 is the date of final separation, and Box 11 is the reason for separation. Retired, resigned, deceased, involuntary separation, or resigned, retired, pending complaint, administrative charge, or investigation for misconduct. And Box 12 states resolution or settlement. If the reason for separation is the result of a resolution or settlement for misconduct, you must note this, as well as advise as to whether this was the result of a criminal charge or investigation, a civil charge or investigation, or an administrative charge or investigation. In Box 13, you must note whether the reason for separation is due to misconduct, pursuant to Penal Code Section 13510.8b. You may also note if the reason for separation is for something other than misconduct. In Section 3, Notice to Separating Officer, you must indicate how the officer was advised that this form will be submitted to post. The separating officer has 30 days to respond to post in writing if they disagree with the reason for separation. And in Section 4, the agency head or authorized designee must sign this affidavit of separation under penalty of perjury. When completing the notice of separation in EDI, you must indicate whether the reason for separation was part of a resolution or settlement for misconduct. If no, you may hit continue. If yes, you must check the appropriate box to indicate whether this was a result of a criminal charge or investigation, a civil charge or investigation, or an administrative charge or investigation. This should be a match to Box 12 of the Affidavit of Separation. You must also note whether the reason for separation was due to misconduct, pursuant to Penal Code Section 13510.8b. This should be a match to Box 13 on the Affidavit of Separation. Just as with the Notice of Appointment, prior to submitting this Notice of Separation, you will be prompted to upload an Affidavit of Separation. You may download this form directly from EDI, or you may go to the Post website and download it from the Forms page. Just as with the Notice of Appointment, you will receive a confirmation that the Notice of Separation was successfully submitted to Post. As a reminder, all previously identified classifications of peace officer must possess a valid proof of eligibility or basic certificate to act in the capacity of a peace officer in the state of California. Basic certificates are issued to peace officers employed by a post-participating agency who successfully completes the appropriate basic course for their classification, as well as successfully completes their agency's probation period of not less than 12 months. A basic certificate is also issued to any peace officer employed by a non-post participating agency whose classification requires a basic certificate pursuant to Penal Code Section 832.4. There are several actions that post may take against a peace officer's proof of eligibility or basic certificate: cancellation, immediate temporary suspension, suspension for a period of not more than 3 years, or revocation. Cancellations most commonly occur as a result of an administrative error. Perhaps a peace officer's probationary period has been extended without post's knowledge. Post issues a basic certificate and is notified after the fact by the training manager that the officer's probationary period has been extended. Post will cancel the basic certificate, and upon notification by the training manager that the peace officer has completed probation and now fulfills all requirements for a basic certificate, will issue a new basic certificate. Immediate temporary suspensions are issued by order of the Executive Director of Post. These are for arrest or indictment for any crime described in Government Code 1029, which would render a peace officer ineligible to hold office as a peace officer in the state of California. They're discharged from employment due to ineligibility pursuant to Government Code 1029, or separation from employment pending investigation into allegations of serious misconduct. Suspension. The Commission decides to suspend a peace officer certification for a period of not more than 3 years. This is tied to the requalification requirement. Revocation. The Commission decides the allegation of serious misconduct is egregious enough to warrant a revocation of the peace officer's certification. Beginning January 1st, 2023, a peace officer's certification status will be noted on their post profile. They will be noted as active, canceled, inactive, revoked, or suspended. Please note that the identification of an inactive certification is not a negative reflection on the certification status. It simply notes that the individual has not been employed in qualifying employment for a period of 3 years or more and may require requalification. If you have any questions about this presentation or the implementation of Senate Bill 2, you may use this QR code to be directed to our information page, or contact me directly at michelle.weiler@post.ca.gov, or you may direct emails to our general inbox at certificates@post.ca.gov. Thank you.